Let's speak to Bruce DelValle, a constitutional law expert who joins me now live from Annapolis in Maryland. Bruce, great to see you. So one of the central arguments in this trial seems to be whether Rittenhouse was acting as an armed vigilante or if he was out and about that night in Kenosha as a civic-minded neighbourhood protector. What do you make of the arguments that have been heard during the trial?
Thank you for having me. I think that the arguments are a little stretched a little thin on both sides. Seeing him as a civic-minded person policing the streets, as of course in America, in many places you're allowed to. In Wisconsin, they have what's called an open carry law, which means you can lawfully carry a gun in the open with certain limitations of the barrel length and whatnot. But the question remains, he lived in Illinois, in another state. He lived 20 miles away. Why did he come there? The question for me, and I think that the prosecution may have missed this point, is did he come there to protect the property of people that he doesn't know, in a community that he doesn't live in, and basically in a dispute that he has no dog in the hunt, if you will? So that's a question in my mind, and he shows up with a gun, with a gun. On the other hand, he had the right to be there to peacefully protest and to counter protest, and he had the right to lawfully ensure that people weren't hurting each other or damaging property. So those are the complex issues. I think the jury's going to have to use its common sense on this one.
Yeah, and surrounding all of this was the fact that it was happening at a time when there was a lot of civic unrest because of racial divisions. And of course, this case, hugely politically divisive. Some saying, look, it centers around self-defense, it centers around gun rights. You know, what repercussions could we be looking at depending on the outcome?
I think this is a very fact-specific case. The long-term repercussions are probably Wisconsin is going to rewrite its laws on open carry and make sure it's much more clear that someone under the 18 cannot carry any weapons. It's a very poorly written law, and that enabled the judge to dismiss that count. But Wisconsin is very clear that if you create the scenario, if you create the danger that you find yourself in, then you cannot then resort to self-defense. If he created the danger by walking around the streets, knowing there was a riot, knowing there was civil unrest, with what appeared to be an automatic weapon, certainly a weapon that looked military, it wasn't a hunting weapon, it wasn't a stun gun, then the jury may find that he created that scenario that put himself in danger, that made him a target of these people that came after him. The other thing that people really seem to forget, and it disturbs me, I hunt, I have guns, and I think issues like this make it much more difficult to support the Second Amendment, because what happens here is people always want to use their guns to kill people or to harm people, and they put themselves in situations where they can do that. So I think in the long run, we may have to re-examine how self-defense works. Historically, it was you could only use deadly force if you had an imminent and real threat of deadly force. Someone chasing you with a paper bag or a plastic bag is not deadly force. One of the people Mr. Rittenhouse killed threw a paper bag at him. The other one hit him with a skateboard. I presume, given enough time and resources and energy and wanting to, you could be grievously injured with a skateboard. But it doesn't, to my mind, self-defense does not mean that if someone acts like they're going to hurt you, that you then get to kill them. It doesn't really work that way. And we need to revisit that.
A lot of right-minded people would say that it is deliberately provocative if you're going out, you're breaking a curfew, you're carrying a weapon. But he was 17. Does that have any bearing on the case, to your mind, the fact that he was young?
Well, I think what happened is he got in his car, or someone put him in a car, and they drove 30 minutes, and it was probably sounded like a real great adventure. He told people he was there to be a medic. He's a lifeguard. He has no formal medical training. He told people he was there to protect against property damage, and he brings a military-style automatic weapon. I think there's other ways to protect against property damage. So as far as him being young, I think it makes him look like he's a little bit foolish and probably a silly boy on an adventure. However, when foolish, silly boys turn deadly, that's a problem. I think the law was supposed to prohibit him from being there with that gun. It was supposed to prohibit him open carry under the age of 18. And this would be cut and dried case to my mind. If you're committing a crime, you can't then commit a crime and then claim self-defense when someone tries to stop you from committing the crime. Who's the wrongdoer here? But the law was very poorly written, and the judge, I think properly, reluctantly, dismissed it. So that's the question. But I'll tell you, I worked with the federal court system for a number of years and sat with juries. American juries almost always get it right. This is an emotional case for a lot of people, but I think those jurors are going to go in there and give us some serious thought. And at the end of the day, they're going to look at this and use their common sense. And one of the things that I find very difficult if I were a juror is, what is a 17-year-old boy doing in the middle of the night in a city he doesn't live in, carrying a military-style, apparently assault weapon, walking around? I just don't think the jury is going to let that pass. I just don't see that.
Really interesting stuff there. Thanks for explaining some of those issues to us, Bruce DelValle there.